The ban took effect Wednesday with concerns that the law could restrict some 85% of abortions in Texas, leading to protests outside the Texas State House in Austin this week.
This law is 100% unconstitutional because Roe versus Wade is the law of the land. Our hopes as abortion advocates is that the Supreme Court will see that and will uphold Roe versus Wade in Texas and across the nation.
The law bans abortions once cardiac activity is detected. It does not make exceptions for rape and incest. Notably, it allows private citizens to sue abortion providers in the state who violate the law or anyone who aids or abets a woman getting the procedure. The person bringing the lawsuit is entitled to $10,000 in damages if they prevail. The White House has slammed the decision, saying it allows complete strangers to inject themselves into the most private and personal health decisions faced by women.
What the president would convey to any woman who is trying to get an abortion, seek an abortion, be able to employ her constitutional right to seek health care and health care that is enshrined and allowed by federal law. What he would convey to them, I don't think he's going to be giving medical advice. That's not the role of any president. He would say, but I would say he would convey to them, I have asked my team, my team to use every lever at their disposal to ensure you have this right, to ensure you have access, to ensure that you can have the ability to seek medical care in the way that every woman should have the right to across the country. And he has made that a priority.
The Republican Texas governor tweeting that his state would defend the right to life and that every unborn child with a heartbeat would be protected from the ravages of abortion.
Our Creator endowed us with the right to life, and yet millions of children lose their right to life every year because of abortion. In Texas, we work to save those lives.
In 2020 alone, Texas performed some 54,000 abortions, and more than 45,000 of those occurred at 8 weeks of pregnancy or less.
We are incredibly disappointed. Essentially what happened in Texas is that they turned the clock back 50 years. It is an incredibly dark day, and in not responding in this moment, the Supreme Court has effectively overruled Roe v. Wade for women in Texas.
While allowing the law to go into effect, the Supreme Court did not rule on its constitutionality. Essentially, what the Supreme Court decision allows for is the implementation of the Texas law to proceed while lower courts resolve some of the technical legal issues around the ban. So in principle, the courts could still determine that the law is in fact unconstitutional, but not after the chilling effect of a change in policy in Texas that denies certain women who are eligible for the procedure what is a federally determined right. Sherwin Bryce-Pease, SABC News, New York.
And we continue the conversation with Sherwin now in New York. So, Sherwin, just tell us a little bit about this Texas law. Why is it called that? And what is the context, especially in the broader theme of prescriptions around abortion in that country?
So it's a bit like our discussion around electoral law in the United States. 50 states determine their own domestic or regional laws that make up the federal collective. It's a similar issue around federal abortion law, which was upheld by the the Supreme Court in 1973. This law known as Roe v. Wade, and what you have is a federal law subject to a balancing test, tying state laws to the 3 trimesters of pregnancy. So it's complicated. In short, you have 22 states, that have laws that could be used to restrict the legal status of abortion. 8 states retain their unenforced pre-Roe abortion bans. 11 states have post-Roe laws to ban all or nearly all abortions that would be triggered were Roe to be overturned. 9 states have unconstitutional post-Roe restrictions that are currently blocked by the courts. And I think you get the idea. If you look at a country like South Africa, for example, it doesn't depend on which province you are in terms of what will apply in terms of the national law as it pertains to abortion. Termination is a decision by a woman. The woman must be under 13 weeks pregnant to end the pregnancy without giving any reason. 13 to 20 weeks can be also terminated, but under certain conditions. More than 20 weeks when the life of the fetus or the mother is at stake. So really comparatively, it's a complicated situation, much like electoral law in the United States.
So the decision by the Supreme Court, what does it do here? Because as you talk about the federal independence of what happens in Texas, what is the effect of what the court has done?
Essentially, they have said that the abortion providers that brought this case to the Supreme Court did not have standing, Tsepiso. They did not have standing in the case because Texas, the state of Texas, is not enforcing this law, and that the individuals that this law basically empowers to sue abortion providers who violate the 6-week ban, they are not imposing, they are at this point are not enforcing the law either. So it was a technical legal argument. The 5 justices in the majority essentially said that the providers did raise serious concerns about the constitutionality of the law, but were not making a decision on the constitutionality as this case actually works its way through the lower courts. It's something that Professor Mary Ziegler of the State University of Florida Law School also weighed in on. Let's hear what she said. Watch.
The reason Texas has done this, I think there are really 2 reasons. One, lawsuits of this kind could effectively bankrupt abortion providers, so they may stop performing abortions, whether there are criminal consequences or not. And more importantly, designing the law in this way protects abortion providers, protects Texas officials from potential lawsuits. If the court doesn't intervene and allows Texas's law to go into effect, we can't 100% conclude that the court will overrule Roe v. Wade because the cases present different issues. But if we're looking to read the tea leaves, it certainly seems that the court is heading in that direction and is not really treating abortion rights with the same gravity the court would treat other constitutional rights.
And one of the main legal arguments against the Texas law, Tsepiso, is that the law violates the courts, the very Supreme Court's Roe versus Wade precedent by making abortion illegal during the first trimester. First trimester of a pregnancy lasts up to 13 weeks of that pregnancy. What the Texas law seeks to do here is to stop abortions at 6 weeks and then have private citizens enforce that law by suing abortions who may violate it.
Says that it will look for legal remedies to this decision, even as the constitutionality of the law works its way through the lower courts. What can, in effect, the federal government do?
Let me just read you a little bit about what a statement from the White House President Joe Biden issued yesterday. He says, I am directing the counsel of the Office of the White House Counsel to launch a whole of government effort to respond to this decision, looking specifically to the Department of Health and Human Services and the Department of Justice to see what steps the federal government can take to ensure that women in Texas have access to safe and legal abortions as protected by the Roe v. Wade decision, and what legal tools we have to insulate women and providers from the impact of Texas's bizarre scheme of outsourced enforcement to private parties. It's something President Biden addressed a short time ago on camera. This is what he said. Watch.
The most pernicious thing about the Texas law is sort of creates a vigilante system where people get rewards to go out to, anyway. And it just seems, I know this sounds ridiculous, almost un-American, what we're talking about. Not to debate about, I respect people who think that, who don't support Roe v. Wade. I respect their views. I respect them, those who believe life begins at the moment of conception and all. I respect that. Don't agree, but I respect that. I'm not going to impose that on people. But what I was told, and I must tell you, I am not certain. I was told that there are possibilities within the existing law to have the Justice Department look and see whether there are things that can be done that can limit the independent action.
So, Pease, just to wrap it up, right, a number of these states are, in fact, passing state laws that seek to undermine the Roe v. Wade decision passed by the Supreme Court in 1973. And I'll just reiterate what Professor Ziegler said. It certainly seems that the court is heading in that direction and is not really treating abortion rights with the same gravity the court would treat other constitutional rights. The long game here is, the big concern is that Roe v. Wade itself could be overturned by this 6-3 conservative majority in the Supreme Court.
All right, thanks, Sherwin, our correspondent out there in New York, Sherwin Bryce-Pease.